Simon, and thanks everybody for coming this morning. As you can imagine, since we've been planning this seminar, things have changed quite significantly. My talk has changed a few times as well. So what I was planning on doing today was running you through the drop in the feed-in tariff and what's going to change. The challenges that have been launched over the last week or so to the consultation, what the commercial implications for registered providers might be, putting their schemes together going forwards, and an overview of the legal steps on two different schemes, being outright purchase of panels and rent-a-roof schemes, and an update on some specific legal points that have come about since our last seminar that we ran. As you probably all know, the Department of Energy and Climate Change announced a consultation on 31st of October, and that runs until the 23rd of December. And that affects installations with an eligibility date on or after the 12th of December. And the new rates that form part of the consultation will come in from the 1st of April. And for installations that are less than 4 kilowatts, that will drop down to 21 pence as opposed to the 43.3 it was previously. But for registered providers, of course, it falls into the multi-installation tariff, so it's a drop to 16.8p rather than 21p. There's been talk in the press recently about for the schemes that are already ongoing, and where there's a rush to get the panels installed as soon as possible before the 12th of December. What's the actual cut-off date for getting the panels installed? There's been talk in the press of it being as far in advance of the 12th of December as actually the 24th of November. That's not actually the case. That came about because the installer has 10 working days to provide the customer with the MCS certificate, which then has to go to the utility company to claim the feed-in tariff. And there was talk about building that period into the time of the installation of the panels. But as long as you get your certificate, then it looks as though the date for the final installation is going to be the 8th of December, which is a Thursday, which allows the submitting of the various paperwork that needs to go to the utility company in order to claim the feed-in tariff. But of course, I'm sure that if panel suppliers have got a large scheme in hand, then they're talking to the utility companies about when is the actual last date, and whether they accept applications by email or electronically over that weekend. But the actual cut-off time is midnight on the 11th of December, which is when the utility company needs to have the application in to claim the higher feed-in tariff. Of course, it is just a consultation that's being run at the moment, but the thinking is that this is going to happen. The Department of Energy and Climate Change has, however, confirmed that as part of that consultation, they won't bring forward the dates of the 12th of December or 1st of April, so they won't make it any worse. I've just given you there the table of the different tariffs. That's the information after we go away, but I'm sure you'll have already seen those already. As I'm sure you've seen in the press, I think it was covered in the news at the end of last week, there have been several challenges to the consultation because of the potential impact on the businesses that have tried to make some progress in this area. I'll just run through what those have been. Inside Housing have got a campaign called the Green Light Campaign, and you can go on their website and that links you to a petition that you can sign. And they're campaigning and calling for the government to provide financial support to protect tenants from fuel poverty through the Green Deal and through PV schemes. The Director General of the Confederation of British Industry has also criticised the move to drop the feed-in tariffs. And this is the one that's hit the headlines. Solar Century is leading a consortium of other solar companies, and they're seeking an injunction to stop the drop from the 12th of December. And they describe the date as being illegal, irrational and unreasonable. The Friends of the Earth also announced last week that if there was no change by Friday of last week, that they'd be seeking a judicial review of the decision. And as far as I can see from looking last night, they're going ahead with that. There's also a possible challenge by local authorities, and the National Housing Federation are also responding to the consultation. Whether any of this will change anything, I suspect not, because I suspect the government's taken quite robust legal advice before taking this step, but we'll see what happens. It'll be an interesting few weeks anyway. So what the commercial implications for social landlords going forward, what can you expect to see the next few weeks and months look like in terms of schemes? We were talking to a lot of different social landlords about the schemes that they were looking at, rent-to-roof schemes or raising finance to buy panels. And the ones that were at the initial stages, people have just stopped working on them for now, and they're just going to hang fire, wait and see what happens. And of course, those social landlords, they are committed to the Green Deal and other PV initiatives. But I think they're going to take it at a more leisurely pace, perhaps not rush into anything. Initially, it looked like funding had pulled out of rent-to-roof schemes completely, but I've been talking to various people over the last few days, and I think that they will come back, but in a different model. And perhaps under those schemes, the association previously would have expected to receive some rent from the panel provider under the rent-to-roof leases, but that's not going to be the case now. But the schemes may be able to stack up still on the basis that they'll break even, but of course the benefit is for the tenants and the free electricity. The difficulty with that, though, is trying to cover the association's costs. They're going to need some income from the panel supplier or the funder because of the high legal costs in getting the lender's consents, particularly if you've got more than one lender. Outright purchase, that is probably still going to be the most favoured option, but the difficulty is because of finance rates. If you're borrowing the money to buy the panels, then it still might not be enough. They might not be low enough for you to break even. But it seems as though the Green Investment Bank may be putting aside a pot of money not only to fund the Green Deal, but to fund PV schemes outside the Green Deal with rates of a possible 2%, which may be enough for allow associations to break even, and so the schemes can go ahead. But I would keep watching as things develop over the next few weeks and months. So moving on to legal steps on buying the panels outright. Those who came to the previous seminar, we went through these in some detail. This is just more of a summary of the legal steps involved, with an update on a couple of particular issues which have come to light in the last few weeks and months. So this is if you're buying the panels yourselves, doing the installation work yourselves and going to be maintaining them either yourselves or with a contractor going forward. You'll need to consider whether you need to check your titles to the properties to see whether there might be any restrictive covenants in there which would prevent you putting the panels on, any covenants against carrying out alterations to the outside of the properties. Of course, there's cost in that. If you're having a scheme of hundreds or in the thousands of properties, for a solicitor to sit down and check every title to see what the covenants might be is going to be fairly costly. Another option is indemnity insurance, where the insurance company takes a sample of your titles and then provides you with a quote for the indemnity insurance. But because of the upgrading work that associations do on a routine basis, such as re-roofing and cladding work, it's not usually something that comes to light in those kind of upgrading works. So it may be something that you take a decision not to do anything, but it's worth considering. Your tenancies will need checking, and usually associations have different variations of tenancies that you've altered over the years, so each variation of your tenancy will need to be checked. And you're checking for the right to install the panels, to host the inverter in the roof space and to maintain them going forward. Tenancies are usually quite robustly drafted for access rights, etc., so there's not usually any problems with those, but that has a bearing on the tenant's consent form and what goes in the consent form. It's been generally seen as good practice over the last few weeks, as this is still quite a new area, for associations to get the tenants to sign a consent form before the panels go on. And this deals with the ownership of the panels, just clarifying that that's with the association, the feed-in tariff and who that belongs to, and also the free electricity. Although that's going to be passed to the tenants, whether it's to reduce the service charge on common parts, or whether it's for their houses or flats individually. Associations have liked to put something in to make sure that tenants can't claim against the association if there's a fault with the panels or if they need to come off for whatever reason. Also, that consent form can deal with or clarify any points if the tenancy isn't quite robust enough. Say if it's a house and you need to host the inverter in the roof, if it doesn't quite allow for that, you can deal with any points that need clarifying in that consent form. Right to buy and right to acquire is the issue I particularly wanted to talk about. We've been advised, taking council's opinion on this, that the solar panels and the apparatus are not classed as fixtures and fittings, they're classed as chattels, which effectively means that if you've got a house with solar panels on and the tenant exercises the right to buy or right to acquire, then the panels and the equipment doesn't automatically pass to the tenant on that sale. It still remains in the ownership of the association. So we need to decide what's going to happen with that equipment on any right to buy or right to acquire sale. Are you happy for it to pass to the tenant and for them to receive the feed-in tariff going forward? Or do you want to retain that in some way? You may want to do that as if you've taken out significant finance costs to raise the finance to buy the panels, and then you're relying on the feed-in tariff income to offset those finance costs. Then you may not want the panels and the feed-in tariff to pass away on individual sales. So what can you do about that if you want to retain the feed-in tariff going forward? What you can do on any sale is for the tenant, at the same time as the sale takes place, is to grant a rent-a-roof style lease back to the association, which in that lease it gives the association, it means the panels stay in their ownership. It gives the right for the association to host those panels on the roof and for them to receive the feed-in tariff. Of course, you can't force a tenant to do that because it affects their statutory rights. So you may have to take a commercial view that you may lose if somebody exercises the right to buy or right to acquire, and if they don't agree to grant the rent-a-roof lease, then you may lose the panels and the feed-in tariff on those properties. But it is something that you may want to include in the tenant's consent form at the start when the panels are going on. Moving on to rent-a-roof schemes, legally speaking, these are the most complex, mainly because of the documents involved and the consents that you need to obtain because you're granting a lease. The documents that you'll have, you may have a 25-year lease and any commercial overarching, sometimes called an option agreement, with the panel provider. And the lease has to be compliant in terms of the Council of Mortgage Lenders. They've issued two sets of guidance, one for residential properties and one specifically for registered providers. And your leases will have to comply with both. Checking the titles is more important on the rent-a-roof schemes because not only are you carrying out the works to install the panels, but you're also granting a 25-year lease. And there may be covenants, particularly if you've recently bought properties, say from the local authority, there may be covenants in those leases that you can't grant a 25-year lease without, for example, the local authority's consent. And in those cases, you'd have to get that consent before you could complete those leases. An option is to obtain indemnity insurance to insure against any breach of restrictive covenant that the granting of the lease or installation of the panels might bring. But again, that's a cost that you might have to factor in at the outset. And again, you need to check each variation of your tenancies. You're checking for the right to install, the right to host the inverter, and maintenance going forwards again. Still on rent-a-roof schemes, the main issue has been obtaining lenders' consent to the schemes. It is possible, but it's costly. and those costs still need to be factored in right at the outset when you're deciding which model to go with, the rent-to-roof or the outright purchase. A few weeks, a couple of months ago, it's talked about costs being about £10,000 per lender to obtain their consent. That's the cost of the lender's charge in that consent, and also their solicitors' costs. But from recent experience, you're probably looking at double that. At the moment, though, that's obviously because of the timescales that have been involved, and it's the lender's solicitors' fees, looking over the documents with a fine-tooth comb to try and get them to be absolutely satisfactory for them. But I think as things progress in the next few months, I don't think you'll be looking at quite that level, but still it's going to be a significant cost. Good news on the section 172 consent. You don't need a separate application for each property. It's one form with a schedule, which has been welcome news, and you don't need a valuation to support that. You do need to inform the HCA of the schemes, but there's no need to consult with the local authority, which is one of the boxes in the form to complete. The tenant's consent form, again, or variation to the tenancy. It's also, again, good practice on these schemes to get the tenants to sign those, and that's to deal with the consent to the works, the free electricity, feed-in tariff, ownership of the panels. There's also a bit of a tricky position in relation to the 25-year lease on a rent-to-roof scheme, because when you've granted a tenancy, in particular of a house, of course the tenancy is for the whole of that house, and it won't necessarily exclude the airspace above the roof, because when these tenancies have been drafted, installation of solar panels wasn't envisaged. So if the house is a tenancy, the whole of the house is already granted, how can you grant a 25-year lease of the area above the roof space that's already been demised under a tenancy? A belt and braces approach would be to obtain a variation to each of those tenancies. But tenants, when produced with a document that looks like a legal document headed up variation to tenancies, they're going to be nervous about signing that. So what's been common practice so far is to include that within the tenant's consent form, and it's the tenants giving their consent to the 25-year lease being granted. To be absolutely prudent, a variation to the tenancy would probably be better, but the lender's solicitors have been happy to proceed with the consent form so far. So it looks as though that's acceptable. And then once you've got that far, with all the consents obtained, because the leases are excluded from the security of tenure provisions, which means that because they're business leases, usually there'd be an automatic right for the tenant to renew the lease at the end of the term, so they need to be excluded from those provisions. So there's notices that need to be served for each lease, and if you're dealing with separate leases for 500 or 1,000 properties, you can imagine the paperwork on preparing those notices is quite substantial. And then you've got to arrange for the leases to be signed, and again, if you're looking at a separate lease for each property, looking at 500 or 1,000 leases, that's also quite significant paperwork involved. So to summarise, especially from talking to people this morning as well, the general consensus is that PV panel installations aren't going away, but they're likely to come back in a different format, different structure, part of the Green Deal perhaps as well. With rent-to-roof schemes, there's some significant costs to take account of up front in making your decision, including lenders' costs, and also title indemnity insurance will be in the thousands as well. If you're going down the outright purchase route, then you need to take account of what happens to the panels and the equipment, and any right to buy or right to acquire, build that into any tenant consent form. And also on each of the schemes, need to prepare the tenant consent form or variation. And contact details. Thank you very much.